The Superior Court of California would like to welcome you to the second part of the Probate Conservatorship course for proposed conservators. I am Sherry Cruz, probate attorney with Riverside Superior Court, and I will be your instructor. This portion of the course will cover conservatorship of the estate. You are only required to view this part of the course if you are seeking appointment as conservator of the estate. During this course, I will outline the responsibilities, duties, and powers of the conservator of the estate, briefly overview the process for establishing a conservatorship, and explain the post-appointment tasks that the conservator must complete once he or she is appointed as conservator and throughout the duration of the conservatorship. This is an informational class for proposed conservators. I will not provide you with legal advice, and we are not entering into an attorney-client relationship. If you need legal advice, you can contact your county's bar association for a referral to an attorney in your area. Also, you may qualify for free legal assistance through a local legal aid organization. For more information about the legal aid organizations in your area, refer to the Probate Conservatorship Notebook. As we discussed in the first session of this course, there are two types of conservators: general conservators and limited conservators. We have already discussed the differences between the powers of a general conservator and a limited conservator of the person. Now we will look at the differences in the powers of a general conservator and limited conservator of the estate. Like a limited conservator of a person, a limited conservator of the estate has no powers unless they are given to the conservator by a court order. Similarly, an order appointing a conservator of the estate does not take away any of the conservatee's rights to manage his or her own estate unless those rights are taken away by court order. The powers and rights that may be specified by the court include the following: taking possession and management of the property of the conservatee, collecting, filing suit with respect to, if necessary, and thereafter to possessing and managing the debts, rentals, wages, or other claims due to the limited conservatee, incurring the contractual or other obligations of the limited conservatee, paying, compromising, or defending, if necessary, the claims against the limited conservatee, and other items with respect to the management of the property of the limited conservatee. Each of these powers and rights may either extend to all of the conservatee's rights or may be limited to specific items. These details in the court's order should also be reflected in the letters of limited conservatorship. Unlike a limited conservator, appointment of a general conservator of the estate automatically takes away some rights of the conservatee. For example, the conservatee generally can no longer buy or sell or give away property, collect debts, execute deeds, sign binding contracts, or prosecute or defend lawsuits. However, a conservatee still retains some rights related to his or her estate. These rights include managing any allowance ordered by the court, managing any salary or wages that the conservatee earns, making a will, and entering contracts to the extent reasonable to provide the necessaries of life to the conservatee in his or her spouse, registered domestic partner, or minor children. The court can add to these rights by a court order. Through the remainder of this course, we will discuss the powers of a conservator of the estate as if you are a general conservator of the estate. If you are a limited conservator of the estate, you will need to look at the court's order or your letters to see what powers you have been given. As conservator of the estate, you will take charge of the conservatee's finances and property. In this role, you will manage the conservatee's finances, protect the conservatee's income and property or assets, make an inventory of the conservatee's property or assets, ensure that the conservatee's bills are paid, invest the conservatee's money, see that the conservatee receives all income and benefits to which he or she is entitled, make sure that the conservatee's tax return is filed and that all taxes are paid, keep accurate financial records, make a budget to determine what the conservatee can afford, and account to the court and to the conservatee for your management of the conservatee's assets. Property, assets, and income that were placed in a trust before the appointment of a conservator or held as community property under the management and control of the conservatee's spouse or domestic partner, are not usually part of the conservatee's estate. You are responsible for understanding the duties that are imposed upon you in carrying out the tasks of conservator of the estate. You must prudently manage the estate for the benefit of the conservatee, which means you must manage the estate property and income for the benefit of the conservatee and with the care of a prudent person dealing with someone else's property. You must make prudent investments, which means you must not make unreasonably risky investments of estate money or property. You must secure court approval to pay estate service fees, borrow money, make loans, and give gifts. This means that you must seek and receive the court's permission before you pay estate fees to yourself for your services to the estate or to your attorney for the services he or she performed to support you in your role as conservator. You must also secure court permission before you borrow money or loan money from the estate or make gifts of estate assets or property. You must keep estate money and property separate from you or anyone else's money or property. You should never deposit estate funds in your personal bank account or otherwise mix them with your or anyone else's funds, even for a brief period. You must identify all assets of the estate, including stocks, bonds, or other securities, security broker accounts, mutual funds, and bank accounts, as the property of the estate and not your or anyone else's property. You must maintain interest-bearing accounts. Estate bank accounts must earn interest, except for a checking account which is used for the payment of ordinary expenses. You must seek court approval for other investments as necessary. Some investments may be made without court approval, while others may be made only after you have obtained court approval. Accordingly, you should consult with your attorney before making any investment. You must pursue claims against others on behalf of the conservatee when it is the best interest of the conservatee or the estate to do so. The court may require you to be represented by counsel to proceed with litigation on behalf of the conservatee's estate. You should consider requesting court permission to pursue or settle large or complex claims that will require the assistance of legal counsel and/or litigation, especially if failing to prevail in the matter may result in an award of attorney's fees for opposing counsel against the estate. Additionally, you must obtain court approval of any contingent fee agreement before it will be enforceable. You must provide defense from claims against the conservatee's estate when it is in the best interest of the conservatee or the estate to do so. The court may require you to retain counsel for your defense of a lawsuit against the conservatee's estate. You may request court approval or instructions regarding the defense or settlement of the lawsuit. You must collect public and insurance benefits for which the conservatee is eligible. Common public benefits include those available through Social Security, Medicare, Medi-Cal, in-home supportive services, and Veterans Administration. Guard against inappropriate disclosure of the conservatee's financial information. Subject to your duty of full disclosure to the court and persons entitled under law to receive it, the conservatee's financial information should be closely guarded against unnecessary or inappropriate disclosure. You must evaluate the conservatee's ability to manage cash and other assets and take appropriate action to request court approval for the conservatee to do so at his or her level of ability. Locate and protect the conservatee's estate planning documents, which includes wills and codicils, living trusts, powers of attorney for health and finances, life insurance policies, and pension records. You must make reasonable efforts to identify, locate, and preserve property mentioned in the conservatee's estate planning documents. Inform the conservatee's family of planned disposal of the conservatee's tangible personal property. Notify the conservatee's family in advance if you plan to dispose of any of the conservatee's tangible personal property with court approval or confirmation and give them the opportunity to acquire it. You must determine whether the disposal of any of the estate property is in the best interest of the conservatee. When making this determination, you consider the likely benefit of disposal of property to the conservatee, the likelihood that the conservatee would need or benefit from the property in the future, current or previously expressed desire of the conservatee regarding the property, including provisions of the conservatee's estate plan concerning the property, whether accommodating the conservatee's wishes for the property would impose an unreasonable expense on the estate or cause you to violate your fiduciary duty to the conservatee, tax consequences of disposing of the property, impact of disposal of the property on the conservatee's public benefits, condition of the entire estate, likelihood that the property will deteriorate or be subject to damage or reduction in value if retained, comparison of the benefit to the cost or liability of maintaining the property as part of the estate. You must determine the appropriate kinds and levels of property, casualty, and liability insurance to cover the property, assets, risks, and potential liabilities of the conservatee and his or her estate. You should review and maintain the conservatee's insurance policies, including those for home, auto, medical, and long-term care insurance, but you may not change the beneficiary of such policies, especially life insurance policies. You must communicate with the conservator of the person and the trustee, if the conservatee has a trust, as necessary and appropriate, and know or inquire about other limitations or restrictions on your authority. There are many limitations and restrictions on your authority not mentioned here. If you do not obtain court permission when you are required to do so, and the conservatee suffers damage as a result of your actions, you may be removed as conservator and or required to reimburse the estate from your own personal funds. As conservator, you are responsible for any misuse of the conservatee's funds or property, even if you do not commit the misuse. Therefore, it is very important for you to limit who has access to the conservatee's accounts, property, and assets. You do not need to seek special permission from the court to do the following as conservator of the estate: pay the conservatee's prior debts, collect debts owed to the conservatee, maintain the conservatee's home, or file the conservatee's tax returns. However, even when you have the authority to act without court permission, if you think your planned action might be interpreted as not being in the best interest of the conservatee, it is a good idea to seek the court's approval before acting. Remember, you must request and receive court permission to do the following: pay for services performed for the conservatorship, which means that you must seek court permission to pay friends and family to provide services or care for the conservatee, as well as to pay yourself for your services as conservator. Pay for services performed by an attorney for the conservator or conservatee, sell real property of the estate, settle various types of claims, including claims relating to real property, which require taking out loans over $25,000, claims against a conservator, wrongful death or personal injury claims, or other litigation, and move the conservatee from his or her personal residence. Pursuant to Probate Code Section 2590, a conservator of the estate may petition the court to be able to exercise special powers without seeking further court permission, including the power to operate a business for longer than 45 days, grant and take options, purchase, sell, or exchange real or personal property, sell the conservatee's personal residence, create easements and servitudes, borrow money, give security for repayment of a loan, purchase real or personal property, alter, improve, raise, replace, and rebuild property of the estate, lease property in excess of $5,000 a month or for a term of more than 2 years, lend money on adequate security, exchange property, sell property on credit with adequate security, commence and maintain an action for partition, exercise stock rights and stock options, participate in, become subject to, and consent to the reorganization of a business entity, including a voting trust, reorganization, consolidation, merger, dissolution, liquidation, or other modification or adjustment. Generally, in order for the court to grant one of these special powers, you must provide a specific reason why you need the requested power. For example, you might request the power to sell the conservatee's personal residence if the sale of the conservatee's home is in progress at the time the conservatorship petition is being considered. In the absence of such a specific need, it is very uncommon for the court to grant these special powers. As we discussed in the first part of the course covering conservatorship of the person, you will need to file a petition with the court to be appointed as conservator of the person and/or estate. The petition for conservatorship of the estate may be filed at the same time and on the same form as a petition for conservatorship of the person. Once you file your petition, the court will set a hearing regarding your appointment. You must follow the proper procedures for serving all necessary parties with the required forms to give them notice of the hearing, and file the proof of service with the court. The court will initiate an investigation into the proposed conservatorship, which entails the court investigator interviewing the conservatee, talking with the conservatee's relatives, and preparing a written report for the court. The court may also choose to appoint an attorney for the conservatee. For more information regarding filing a petition, completing service, and the conservator appointment process, please refer to the first part of this probate conservatorship course, which covers these topics in detail, and the probate conservatorship notebook. Once you're appointed conservator of the estate, you must complete several time-sensitive tasks, including posting a bond, sending notice of conservatee's rights, if the estate contains real property, recording the letters of conservatorship with the county recorder of the county where the property is located within 90 days of your appointment as conservator, opening a bank account in the name of the conservatorship using the conservatee's Social Security number, filing and serving the inventory and appraisal within 90 days. If the conservatee's residence will change, providing notice of the conservatee's change in residence to the necessary parties, filing the first accounting or waiver of accounting 1 year after the date of your appointment as conservator, and every 2 years thereafter, unless otherwise ordered by the judge. To complete these post-appointment tasks, you'll need the following forms: notice of conservatee's rights, declaration, inventory and appraisal, notice of filing of inventory and appraisal and how to object, pre-move notice of proposed change of personal residence of conservatee, post-move notice of change of residence of conservatee, and accounting forms. Visit your court's website or the Judicial Council's website to download fillable electronic versions of these forms. As conservator of the estate, you must secure a bond. A bond is like an insurance policy, which will protect the conservatee from loss that is a result of the conservator's misconduct or neglect of his or her duties of the estate. The bond allows the conservatee to be reimbursed by the insurance company, which will, in turn, collect from the conservator. You must secure any bond ordered by the court before the court will issue you the letters of conservatorship. Some bonding companies may require that you are represented by an attorney before they will issue you a bond. If you are self-represented and the bonding company you select will not issue you a bond unless you have an attorney, you will either have to select another bonding company or retain an attorney to assist you in obtaining the bond. The amount of the bond will be fixed by the court before the appointment hearing. The bond amount is the sum of the following: the value of the conservatee's personal property, the conservatee's income from all sources for 1 year, and the bond recovery cost as prescribed in California Rules of Court. The cost of bond recovery is a specified percent of the value of the estate, and that percent changes as the value of the estate increases. The bond recovery amount is 10% of the value of an estate up to and including $500,000. 12% of the value of an estate above $500,000, up to and including $1 million, and 2% of the value of an estate above $1 million. Pursuant to Rule 7.207, the value of the estate includes the value of personal property, the annual income of the estate, and the gross annual payments under Probate Code Section 2320, which includes social services payments for aid and medical assistance, the care of children, or county aid and relief for indigent individuals. If the court has granted the conservator the power to sell the conservatee's real property without approval or confirmation of the court under Probate Code Sections 2590 and 2591, the value of real property, less encumbrances, will also be included in the value of the estate for bond purposes. If the bond amount becomes insufficient, for example, if the conservator's income increases, you must inform the court of the change and secure a new bond for a sufficient amount. Here are some of the types of assets and income that you would include in the calculation of the bond amount. The formula for calculating the bond is the conservatee's total liquid assets plus the conservatee's income plus the conservatee's real property for which the conservator has 2590 powers plus bond recovery cost. Here the bond recovery cost and the total amount of the bond is calculated using the total assets and income from the previous slide. There are two circumstances in which the court will allow you to post a bond for less than the value of the conservatee's estate or forego the bond requirement altogether. First, if you block the conservatee's accounts by order of the court, which means the accounts can only be accessed by court order, you will only be required to post a bond for the amount of income and assets that are not blocked. The bond calculation will not need to include the amount of the accounts that are blocked, but everything else, including the bond recovery cost for the assets besides the blocked account, must be fully bonded. Second, pursuant to Probate Code Section 2323, if the value of the conservator's estate is under $15,000 and the conservatee's monthly income, excluding Social Security, is less than $2,000, the court will not require you to post a bond. The letters of conservatorship, which serve as proof of your authority to make decisions regarding the conservatee's estate, will not be issued until you have purchased a bond and filed proof of the purchase with the court. If the conservatee owns any real property, you will have 90 days from the date of your appointment as conservator to record the letters of conservatorship with the county recorder of the county where the property is located and file a declaration with the court indicating the date when and the location where you recorded the letters. You must open a bank account in the conservatorship's name, that is your name as conservator for the conservatee's name, and use the conservatee's Social Security number. Using the conservatee's Social Security number will ensure that the conservatee's estate, rather than you personally, will pay any taxes on the interest. The account must be interest-bearing. Otherwise, you may be surcharged for the interest that would have been paid to the estate. However, if you can show that the bank's service charges for an interest-bearing account would exceed the interest generated by the account, you can elect to open a non-interest-bearing account with no service charges. You should also be mindful of the FDIC insurance limits and not place more than $250,000 in any one bank. If the account is to be blocked by order of the court, the bank will issue you proof of the blocked account, which you should file with the court. As conservator of the estate, you will need to prepare an inventory. That is, make a list of all the real and personal property of the estate. The inventory and appraisal is a snapshot of the conservatee's assets on the date of your appointment, not the date the letters of conservatorship are issued. To complete the inventory and appraisal, you must use Form GC-040, Inventory and Appraisal, and Form GC-041, Inventory and Appraisal Attachment. You will list cash assets on attachment number 1 and non-cash assets on attachment number 2. Cash assets include savings, checking, and money market accounts. Other assets, such as real property, vehicles, and securities, fluctuate in value and are called non-cash assets. List non-cash assets on attachment number 2, but leave the value of each item blank. You must then send the inventory to the probate referee whose name appears on your order appointing conservator. The probate referee will provide the value for each item and will return the completed document to you with a bill for his or her services. You should pay the probate referee's fees from the conservatee's funds. Provide enough details about non-cash assets to allow the probate referee to appraise each item. The probate referee may request additional information or documentation to assist in his or her valuation of the conservatee's property. You will also need to serve the notice of filing of inventory and appraisal and how to object on the conservatee and the conservatee's relatives through the second degree. If you wish to sell the conservatee's home, you must first obtain permission from the court. Before it gives permission to sell the conservatee's home, the court will ensure that you have asked the conservatee whether he or she agrees with the sale, and that you have considered any alternatives to selling the home, including providing in-home care services that would allow the conservatee to continue living in his or her home. The court will also ensure that you have considered whether the home can be rented rather than sold in order to allow the conservatee to return to live in the home if he or she becomes well enough to do so. If the court allows the sale of the conservatee's home, then the sale must be court supervised, and a new appraisal of the conservatee's residence must be obtained if the last one was conducted more than 6 months prior to the date of the hearing on the report of sale and petition for confirmation of the sale of real property, unless the court finds an appraisal completed not more than 1 year before the hearing is sufficient. The first accounting of the conservatee's estate is due 1 year after the date you were appointed as conservator. Subsequent accountings are due every 2 years, or more often as ordered by the judge. There are 2 parts to an accounting: the report and the schedule. The report is a pleading or form that is a petition requesting approval of the accounting, and may also request other orders such as approval of conservator or attorney fees. The report tells a story of what has happened to the conservatorship estate during the date range of the accounting and provides several statements that are required by law. The accounting schedules are faintly similar to income tax forms. They start with Form GC-400 that summarizes all of the economic activity during the date range of the accounting. Each number provided on this summary is then subject of an itemized schedule. Accountings cover the period since the last required or waived accounting period, usually 2 years, or in the case of a first accounting, the first year of the conservatorship. In compliance with Probate Code Section 1061, the accounting must report the following information: beginning balance, gains or losses on sales of property, receipts, disbursements, and ending property on hand. The accounting must also include the original escrow closing statement for the sale of any real property, the original care facility statements if the conservatee resides in such a facility, and the original statements from the financial institutions that hold the conservatee's assets. It is important that you maintain good records because the court may audit your accountings. The court can conduct a full or partial review of your accountings, and you're required to make all books, records, and receipts available to the court upon request. Pursuant to Probate Code Section 2628, the court may make an order that the conservator is not required to file an accounting if the following conditions are satisfied: the conservatee's estate, at both the beginning and end of the accounting period, has a total net value of less than $15,000, excluding the value of the conservatee's residence. The income of the estate for each month of the accounting period, exclusive of public benefit payments, is less than $2,000, and all income of the estate, if not retained, was spent for the benefit of the conservatee. If the estate meets these requirements and you wish to waive the accounting, file the appropriate form with the court. As conservator of the estate, you are responsible for the payments for services made using the conservatee's estate funds. All fees must be reasonable. The court may ask you to prove the reasonableness of any payments that you ask the court for permission to pay as conservator of the estate. The court may choose to reduce fees that it believes are not reasonable. In determining the reasonableness of fees, the court will look to the size of the estate, the benefit that the conservatee derives from the services, the necessity of the services, and whether the hourly rate and an itemization of services provided are included in the fee request. If you wish to be reimbursed for your services as conservator, you will need to track the time you dedicate to your role as conservator and the activities you perform for the conservatorship. It is important that you keep good records of all of the time you spend administering the conservatorship, as the court will want an itemization of your fees. You may seek periodic payment for your services, or you may seek payment for all of your services at the end of the conservatee's life. But remember, you must seek court permission to pay yourself for your services as conservator, or to pay for the services of attorneys, friends, and family who provide services for the conservatorship. You may be removed as conservator and/or surcharged for behavior that is inconsistent with your duties as conservator, including poor management of the estate, paying yourself or your family and friends for services to the conservatorship without court approval, failing to file an inventory or accounting, making material errors in the accounting, personal use of the conservatee's assets, violating court orders, or other good cause. You have completed the probate conservatorship of the estate course for proposed conservators. Please be sure you complete your declaration of completion and file it with the court at least 4 court days before your hearing. If you have any questions regarding your conservatorship petition, you may contact your court's probate department. However, keep in mind that probate staff may only speak with you regarding procedural matters and will not give you legal advice regarding how to handle your case. Thank you for your time and attention.